If you think the Uber tax case was just about who pays payroll tax, think again. In the previous video, we've discussed Chief Commissioner of State Revenue and Uber Australia in the context of Payroll Tax Act and three key issues in the judgment, including the nature of the driving service, scope of exemptions, and payment for or in relation to work. These issues, however, are only 3 out of 11 issues identified in that case. In this video, we will navigate the balance of the disputed issues and answer these questions. Firstly, what the Uber ruling actually means. Secondly, how the same legal principles could apply to DoorDash. And thirdly, what this might mean for the future for delivery work, payroll tax, and digital business models in Australia. Let's dive in. When the Payroll Tax Act was written in 2007, the gig economy didn't exist. No one imagined that a smartphone app would one day connect millions of micro-contractors in real time. Between 2015 and 2020, Uber expanded quickly in Australia, but by 2025, Uber was facing more than 80 million in payroll tax assessments. The New South Wales Chief Commissioner said Uber isn't just an app, it's a business that earns from people's work, and that work is taxable. Uber disagreed. It claimed to be a digital marketplace, not a transport company, a mere intermediary between drivers and passengers. At first, the Supreme Court bought that argument, but on appeal, the New South Wales Court of Appeal didn't just overturn the ruling, it rewrote how we think about digital labor relationships. The court tackled 11 issues. Check my last video that covers issue 1, 6, and 9, and we are going to unpack the remaining 8 issues. Firstly, let's talk about Uber's rating system, including whether rating was a service supplied by drivers to Uber under the driver contracts, was that insignificant, and whether ratings was ancillary to the use of the driver's vehicle. Firstly, let's look at Uber's arguments. Uber, applying the Sarah Lee test, submits that rating was not just a service supplied under the driver contracts. They pointed out that under the driver contracts, the driver would be prompted by the Drive app to provide rating of the rider, but not forced to do so. Uber also argues that the drivers won't get paid off ratings of the rider. Besides, Uber submits that service of rating supplied to Uber was de minimis, meaning it is so trivial that it should be disregarded anyway. Uber's position is that the process of rating took only a second or two and involved pressing 1 or 2 buttons on the driver's phone, so it's not a big deal, and the court doesn't need to give any concern to it. Lastly, Uber argues that rating was ancillary to the use of drivers' own vehicle simply because a driver cannot rate a rider if they have not used the vehicle. This creates the exemption under Section 32, subsection 2 of the Payroll Tax Act, which we covered in our last video. What's Chief Commissioner's response? Well, the Chief Commissioner maintains that rating was a service provided under the driver contracts because the drivers were practically obliged to rate the riders after each trip before they could use the Drive app to start another trip. Further, by interpreting the Uber's driver contracts, rating is compulsory while leaving feedbacks are optional. In response to Uber's argument that rating involving only pressing 1 or 2 buttons, the Chief Commissioner argues that such process requires the driver to assess and evaluate the rider during the journey, and it has significant value to Uber because it contributes, among other things, to the enhancement of safety. The court noted that rating rider was a service necessarily provided to Uber in the exercise of drivers' rights under the contracts, and was therefore supplied under these contracts. It doesn't matter whether driver is paid or not by doing the ratings. The court also finds that activity of rating must have been seen as of value, particularly in light of the safety purpose for collecting such feedback about riders. The court concludes that it was effectively an essential part of the driver continuing to make use of the driver app. As to whether rating was ancillary to use of vehicle, the court says that the driver was forced to rate because the driver app required them to do so. Therefore, driving is not ancillary. It's not just an accessory to vehicle use. It is the core service. As such, the exemption in Section 32, subsection 2, subsection 8 did not apply. Now let's look at whether a referring system was supplied under the driver contracts. Uber says that referral scheme, or put in technical way, published offers, was under separate incentive contracts, not under the driver contracts. Such referring could be performed outside of using driver app. Further, Uber states that even if referring is a service under the driver contract, it is de minimis, being of insignificant nature, because this could be done quickly and simply with only a few buttons pressed or mouse is clicked in the driver app or online to share a referral code with the other person. Chief Commissioner argues, on the other hand, that those referral benefits included the entitlement to receive incentive payment as set out in the driver contracts. It was submitted that the referral system is properly described as policy related to feature or functionality of the driver app, because one of the ways in which a driver could qualify for a referral bonus was by using in-app referral button, and this scheme was only available to drivers. In summary, referring a person is not just a quickly pressing button, but involves persuading potential drivers of the benefits of being an Uber driver. So what's the court's view? The court does not accept that referring service itself is de minimis, i.e. not important, as it was an activity contemplated in Uber's own material. Now move on to the flow of payments and legal characterization, being the requirements of Section 35, subsection 1. When money passes through an app, who is actually paying whom? Uber said it's just a process found from riders to drivers taking a small fee. The Chief Commissioner, on the other hand, relied on two cases, Thomas and Naz and Optical Superstorm, and argued Uber's interpretation of term payroll is too narrow. What's the court's finding? Well, Uber's control over pricing, collection, deduction, and distribution determine how the money flows. That makes Uber's payment to drivers payments for work. The court dismissed the notion that Uber was merely a collection agent. The takeaway point is control of payment equals ownership of the transaction. And in tax law, ownership means accountability. So you can't raise agency as a defense. Now let's look at the last issue, which is about remission of premium interest. Losing a tax case is bad, but having to pay interest and penalties make it far worse. Under the Payroll Tax Act and Taxation Administration Act, when liability is found late, authorities often impose premium interest higher than market rate as penalty. Courts can remit or reduce part of that interest if there are special reasons. The primary judge had ordered full remission of premium interest in Uber's favor. That is, Uber didn't have to pay the full penalty interest. The Court of Appeal found that was error of principle, particularly because the judge relied on no willful default too casually. The Court of Appeal ordered that only 50% of premium interest should be remitted. That is, Uber must pay half of the penalty interest. Uber's case makes people wonder who is the next tech giant that may face a big fine notice. So how different is DoorDash really? DoorDash, like Uber Eats, connects customers, drivers or dashers, and restaurants through an app. It takes a service fee from each order, just like Uber's ride fee. But here's the kicker. DoorDash also sets the pricing structure, the delivery radius, the payment formula, and app-based rating system that decides who gets paid more jobs. Sound familiar? Structurally, DoorDash's relationship with dashers is almost identical to Uber's with drivers. And that's exactly why regulators and courts will look at DoorDash next. What happens when you apply the Uber judgment line by line to DoorDash? Let's run through the key issues. Firstly, who is the service supplied to? DoorDash may say dashers deliver food for restaurants and customers, not for DoorDash. But the court's reasoning in Uber case says, if your business revenue depends on that work, the service is supplied to you too. Just like Uber, DoorDash earns a commission per delivery. So the DoorDash's work directly generates DoorDash's income. Make it a service supplied to DoorDash and a Dasher contract. Number 2, is delivery ancillary to vehicle use? DoorDash could argue that deliveries are ancillary to the driver's use of their vehicle, exempt under Section 32, subsection 2, subsection A of the Payroll Tax Act. But the court said no in Uber case. The human act of driving is not ancillary, it's the core service. By that logic, picking up and delivering food is the essential service, not a byproduct of using a car or bike. Number 3, are DoorDash payments for work? Under Section 35, subsection 1, wages include payments for or in relation to the performance of work. DoorDash pays dashers per completed delivery based on distance, time, and difficulties, just like Uber pays per ride. That direct connection between work performed and payment amount easily meets the court's test. So yes, those payments will likely be seen as for work. Number 4, control and integration. The Uber judgment heavily emphasized on control and integration, even when workers could reject jobs. DoorDash uses similar mechanism. Delivery offers through the app, rating systems that affect future work, algorithmic control of job distribution. That's not passive facilitation. That's operational control. The court would likely say DoorDash doesn't just enable deliveries, it orchestrates them. So what are the consequences? Unless an exemption applies, DoorDash could be deemed an employer and its Dashers' employees for payroll tax purposes. That means DoorDash could earn backdated payroll tax on all Dasher payments, plus penalties and interest possibly reaching tens of millions. So what's next? How the court's wider reasoning traps platforms. The Uber case didn't just answer who is liable, it rewrote how we define work in a platform economy. The court said the focus isn't on formal employment, but on economic dependency and benefit. If a platform sets prices, determines workflow, manages performance through ratings, then the platform is participating in that work, not standing outside of it. So when a DoorDash driver delivers a meal, they are not just helping a restaurant, they are directly performing DoorDash's core business function, delivery. Under the same reasoning, DoorDash's entire operational model could easily trigger payroll tax liability. Let's zoom out. The Uber ruling doesn't turn contractors into employees. It erodes the legal fiction that digital platforms are neutral. For regulators, it's a signal if you profit from someone's labor, you are in the business of work. For DoorDash and platforms alike, this could mean retrospectively audits from state revenue offices, the need to register for payroll tax, and perhaps a rethink of its business model to reduce exposure. For other gig platforms like Menulog, Panda, Didi, or even Upworks, it's a wake-up call. They might be the next in line. Can online business platforms like DoorDash fix this before it becomes the next Uber? Possible solutions include restructuring contracts to make delivery businesses genuinely independent, lobbying for legislative reform, for example, to create a new tax category for platform work, or negotiating settlements before massive liabilities build up. But the bigger question remains, how do we balance innovation with fair taxation in a world where work is done by swipe of a screen? When the court said Uber was in the business of transportation, it quietly drew a map for every platform in Australia. Uber may have lost this round, but it's won us a clearer view on how old laws adapt to new realities.